Meanwhile, the state attorney general took legal action today, challenging the Defense of Marriage Act, or DOMA as it is known. In a friend of the court brief, he argued that the law is unconstitutional and also an improper intrusion on the traditional role of states in defining marriage. Joining me now to talk more about this legal challenge is the Solicitor General of New York, Barbara Underwood. Ms. Underwood, thank you very much for joining us. It's great to have you here.
I'm glad to be here.
So let's just start with this. First of all, it's what's known as an amicus brief, right? So it is not a lawsuit that the state attorney general is bringing himself. Is that right?
That's right.
And what does that mean? It's a friend of the court brief, so what does that mean?
Well, what that means is that sometimes, actually fairly often, in a case in which the state is not a party, or the Attorney General is not a party, we have a point of view that is a little bit different from that of the parties, or some information to bring to bear. So in this case, the parties are arguing about their rights, and we're very concerned about their rights, but our special perspective is that the state has an interest in not having its policies undermined.
Right.
So,
well, because this is, for people who might not be aware, DOMA, as it's known, or the Defense of Marriage Act, is a federal law that actually says that one state doesn't have to recognize the same-sex marriages of another. So we just had same-sex marriages now legal in New York, and so a person who got married, say, this Sunday, might go to a state where they don't have similar rights and their marriage would not be recognized. Is that the concern?
yes, well, actually, the part of DOMA that's at issue in this case is that DOMA says that the federal government, that for purposes of any federal law that makes marriage relevant, marriage is defined as between a man and a woman. So a marriage that is valid in New York nevertheless doesn't count for purposes of federal benefits. For example, the plaintiff in this case is her problem, or her challenge arises from the fact that if her marriage were valid, she'd have a spousal exemption from the federal estate tax.
Right, right.
But because actually, DOMA doesn't say that the New York marriage isn't valid. They just say it doesn't count as a marriage for purposes of federal benefits, or for purposes of any federal law. But there are many, many federal law provisions that affect married people, and so depriving same-sex couples of those benefits basically undermines New York's effort to treat same-sex couples equally with opposite-sex couples.
Well, in this particular case, the issue was actually estate taxes that one partner, a spouse, could not collect after her spouse had passed away. But what else is there in federal law that is at risk here?
Well, there are spousal Social Security benefits, spousal veteran benefits. There are many, many federal laws that make marriage relevant and that under DOMA are simply not applicable to same-sex married couples. And that treats New York married couples differently depending on sex and sexual orientation, and it undermines the traditional role of the states in defining marriage.
Well, that's another issue here, right? I mean, there's actually almost two pieces here. One is about same-sex marriage, but the other is about state sovereignty and states' rights, the ability of states to make their own decisions. Is that also in play?
Well, there's a federalism concern that's at issue here. We're not arguing quite that there is what we're arguing is that the equal protection claim brought by these plaintiffs is that the statute should be strictly scrutinized, or should receive heightened scrutiny because it discriminates on the basis of sexual orientation and sex. And what the New York brief says is yes, and Another reason that the statute should be strictly scrutinized or receive heightened scrutiny is that it intrudes on the traditional role of the states in defining marriage. And with a sufficiently compelling interest, Congress could do that, but no such compelling interest exists here. So these are all reasons why this discrimination ought not to be permitted, and Attorney General Schneiderman has been committed to equal treatment of same-sex couples, and indeed the law of New York has for a long time, even before the Marriage Equality Act, been committed to equal treatment of same-sex couples. And so this undermines a strong, well-rooted New York policy.
Are you saying, though, that the state didn't have standing until the gay marriage law actually was enacted, until it took effect, which happened obviously this past weekend, as we've been reporting ad nauseum now? Did the state not have standing to do what the Attorney General has now done until that happened?
No, that just makes it a stronger case.
I see.
The state's commitment to, for instance, the state's recognition of same-sex marriages from other states and its prohibitions on discrimination on the basis of sexual orientation all predate this. But the Marriage Equality Act reaffirms and confirms and advances New York's commitment and makes it all the more important and appropriate to ask the court to strike down this federal interference with a strong New York policy.
Do we know a timeline at this point? Do we have any feeling about when there will be a decision in this particular case that now New York is party to?
Well, there is a briefing schedule that allows for the filing of briefs over the course, by the parties over the course of the next, it's through August and I think into September. So quite apart from, I mean, the plaintiffs have filed a motion for summary judgment, and the defendants are going to file a motion, another cross motion to dismiss the complaint, and the briefing of all of that will extend over a period of weeks, at least.
At least.
And the judge won't decide anything till all those briefs are in.
Okay, so what
we're...
Please continue.
No, I believe the judge has, up until now, shown an interest in expediting, in moving the case along without delay, but everybody has to have time to file their briefs.
Right. So we're looking at least a number of weeks. It's not something that's imminent within a number of days.
Oh, absolutely. Weeks or months.
Oh, boy. Okay. Well, we'll be following it, of course, but it is a pretty interesting development. I want to thank you very much, Ms. Underwood, for joining us. It's a pleasure seeing you.